Whether HDMI is a trademark, a brand, or a technology. Let's talk about it.
We recently went through one Delhi High Court order in the case of HDMI versus Messrs. Eka, wherein the court restrained one of the party dealing in television, incorporating the same HDMI port but without license.
In this case, plaintiff claimed that 5 entities came together in the year 2002 and created HDMI, that is High Definition Multimedia Interface. These 5 entities were Hitachi, Panasonic, Philips, Sony, Toshiba. And it is the plaintiff who makes sure that any party who wishes to incorporate HDMI technology on their televisions or any device has to take license from the plaintiff. HDMI also claimed that apart from having international registration, it has also obtained 4 trademark registrations in India. First one is the word mark itself, that is HDMI. Second one is this iconic logo of HDMI, and the third and fourth are nothing but the shape device itself, that is the port. Furthermore, if you see the order, there has been no mentioning of the fact if they have the patent of the technology. You should note that this was a trademark infringement and passing of suit and not a patent infringement suit. Now you might think that Delhi High Court has passed an order restraining defendants from using HDMI on their devices, so it has become a precedent, a law. But is that the case? The present order was passed without the presence of defendant for the purpose that plaintiff wanted to execute a raid at the location where the televisions with HDMI technology used to get manufactured or being sold. For that, there was no advance service and there was no one who was appearing on behalf of defendant, and this matter was heard and decided without the presence of the defendant. Therefore, this was an ex parte order. Furthermore, it did not require a full-fledged trial because it was an interim application for injunction which was sought. Therefore, it was not a full-fledged trial and therefore it was a ad interim injunction. So combined, it was an ex parte ad interim injunction order. So whether an ex parte ad interim injunction order has a precedentiary value? Well, Honorable Supreme Court in the case of State of Assam versus Bharat Biotech held that an interim order is not a precedent. You may refer to para 21. So whether HDMI is a technology, a brand, or a trademark is something which will be decided by Honorable Delhi High Court if in the case the defendant wish to contest the same.
However, the question is whether one can have trademark of an abbreviation of a descriptive mark. For this, we will have to look into the case of Bharat Biotech versus Optimal Health. In this case, it was again a matter of trademark infringement and passing off. Here, the plaintiff's trademark was type bar TCV and the defendant's trademark was Zyvac TCV. And plaintiff had an issue that the defendant was using the trademark TCV. In the year 2008, plaintiff claims that plaintiff had invented a new vaccine for typhoid, namely typhoid V capsular polysaccharide tetanus toxoid conjugate vaccine, and for which it applied for patent in India and at the same time had patents already in other countries, and thereby suggesting that the plaintiff had created TCV. Plaintiff also has 2 trademark registered in India for the mark TCV. Therefore, plaintiff argued that the defendant should be restrained from using the mark TCV in its packaging.
So court held in this case that an abbreviation of a descriptive mark should not be given any trademark protection. Even if the person X is the first one to have abbreviated that descriptive mark and using it as an abbreviation, then also he is not entitled to any protection under the garb of a trademark registration. Court further held that even if the plaintiff has a trademark registration for an abbreviation of a descriptive mark, the plaintiff will not be entitled to any trademark protection and such registration is illegal and is liable to be cancelled. And it is plaintiff's own case that TCV is an abbreviation of typhoid VI capsular polysaccharide tetanus toxoid conjugate vaccine. Therefore, considering the fact that this word TCV is an abbreviation of a descriptive mark, the same mark should not have given any trademark protection at first place. It should not have been registered at the first place, and the same is illegal unless such abbreviation of a descriptive mark has attained a secondary meaning, a distinctiveness. But whether such abbreviation has gotten or attained a secondary meaning is something that is a matter of trial. It will require a full-fledged trial, not at the interim stage. Is something what Honorable Delhi High Court held in this case. So therefore, on an interim basis, no one can claim or be entitled to a trademark protection if such mark is an abbreviation of a descriptive mark, because at the end of the day you will have to prove that it has attained a secondary meaning, and for that you will require a full-fledged trial which cannot be done at the interim stage. And therefore at the interim stage you're not entitled to any trademark protection if the word is an abbreviation of a descriptive mark.
So to answer, one cannot claim trademark protection at the interim stage if it's an abbreviation of a descriptive mark.
So academically speaking, if court passes an interim order, such interim order are not precedent or law as a matter of fact. Therefore, a person who is aggrieved by such interim order is entitled to go to appeal or challenge the same or file an application for the vacation of an injunction. I hope this video was helpful. Thank you.